Uh, so first we'll go through an introduction of who we are and what we do. I'll be last. And Sarah, did you want to go first? We have Catherine Tasmer and Sarah Colburn here. Sarah, do you want to lead off with your introduction?
Yes. Hi, everyone. I'm Sarah Colburn. I have been working at Cantor Colburn since around 2014. I have been in both the litigation and transactional departments. So that's what I've been doing now.
Thanks. Catherine, you want to?
Sure. Just to follow up, Sarah, my name is Catherine Tasmer. I'm a member of Cantor Colburn's litigation department. I also do transactional work and trademark and copyright work. And I've been with the firm since around 2012. I worked my way up as a litigation paralegal, went to law school at night, and here I am as an associate.
Great, thanks everybody. So I'm David Baumser. I'm a partner here at the Hartford office, and I focus on patent procurement, which is dealing with the U.S. Patent Office and inventors to try to get the patents, and I work on transactional matters too. And I've been involved with over the years in litigation matters and all types of IP related matters. So today's agenda you see here is going to be patents, trademarks, and copyrights. We're going to do a little discussion about each, what they are, and then the relevant transactional issues related to these topics. All right, let's see, sorry about this. Okay, all right, disclaimer, starting off the onset. So we're not giving you legal advice. We're not your attorneys. If you have specific questions, please feel free to contact us. We'd love to work with you. But when you do contact us, don't give us any confidential information because it's not going to be protected by the attorney-client privilege until we enter into a formal agreement. But we'd love to talk with you and see where things can go. The views we express are ours and not those of our colleagues or the firm. So you'll hear more about this as we go, but just basically, what is intellectual property, IP? You have copyrights, original works of authorship, music, books, trademarks, which are source of quality identifiers such as Coca-Cola, the Hartford, Aetna. Trade secrets, information that derives economic value from not being known, which is the formula for Coca-Cola, as an example. KFC's original recipe. And patents, which protect the rights of useful inventions. If anybody have any questions along the way, please let us know. So what is a patent? Concepts, what's patentable? Concepts of the useful, novel, and not obvious over previously known concepts. Patents give you the right to exclude, not the right to practice the patent. It's right to exclude others from making, using, importing, or selling, offering for sale your invention within a territory that your patent is granted. So U.S. patent is viable in the United States. And there's the U.S. Patent Office below. And you can obtain a patent by filing a patent application with a government patent office around the world. A U.S. patent office gives you a patent in the U.S. By the way, this is Eddie Van Halen's patent. If any of you have ever been interested, he does have a patent for guitar design. There are design patents. And so a design patent, utility patent protects the way a functional article is used, it works. And design patent protects the way a functional article looks, what can be seen by the ordinary observer. Both design and utility patents can be obtained for an article if it has both function in its design and the ornamental features of the design are novel and not obvious. Graphical user interfaces are patentable, and I have a couple of examples here of different interfaces for Sony and Symantec. And in the graphical user interface or in any design patent, solid lines are claimed, which means in a potentially infringing product has to have it. And the rest of the lines are in the environment, which means it doesn't have, the potentially infringing device doesn't have to have it. However, to infringe a design patent, the potentially infringing device has to, in the eyes of the ordinary observer, be the same as the patented article. So the more stuff you have in dashed lines may lead someone to feel that the other product is or is not the same. So that's the first step of the question for infringement of a design patent. And the second step is, does it have these solid lined features? All right. So how does a utility patent work? So again, it doesn't give you the right to practice, it gives you the right to exclude, right? So we have three examples here, three different companies, A, B, and C. They each have a patent for their own design of a chair. Company A has US patent number 1, company B has US patent number 2, company C has US patent number 3. Their claims, their broadest claims are on the bottom. The claims define your scope of protection, and the claim for patent company A is the broadest. It has the fewest number of words in the claims. A chair comprising a seat and 2 more legs. That's pretty broad. Company B has a chair comprising a seat, 2 more legs, and a backrest in its patent. Company C has a chair comprising a seat, 2 more legs, a backrest, and curved feet. It's a rocking chair. So if company A wanted with its right to exclude, company A has the right to exclude company B and C from making their chairs, even though they have their own patents to their chair designs. Company B would have to get a license from company A to make its chair. Company B would also have the right to exclude company C because company C's chair has more features than company B's patent. So company C would have to get a license from both company A and B to make its chair. So again, so kind of trying to show you here that, again, the patent uses the right to exclude, not the right to manufacture. So what is a trade secret? So the Defense of Trade Secrets Act, which is a federal statute, defines a trade secret as all forms of and types of financial, business, scientific, technical, economic, engineering information. If the owner takes reasonable measures to keep it secret, for example, with NDAs, as we'll discuss in a bit, or otherwise marking the information as proprietary, and the information derives its value from being not known, which is what we mentioned before. So if you're going to get a patent or a trade secret, which do you do and why? Well, trade secrets have certain advantages over patents in that patents have expired 20 years after the initial filing, where trade secrets don't necessarily expire ever. There's no filing with any type of government office for a trade secret. The effect is immediate. You have to wait years for a patent office to decide whether or not you can have protection. And it's not prosecuted by employees at the patent office. Disadvantage is that once a secret is made public, it's no longer a trade secret and it can't be protected, which is where a patent is much more valuable. It's difficult to enforce without strong evidence of misappropriation, which means you have to show somebody stole it from you. And that's going to be hard to show unless you're diligently trying to protect information with NDAs and proper markings on your information that you're sharing. You have to have documented policies, for example, for your NDAs and your markings, and you have to show those to a court if you want to say that someone is stealing, is misappropriating your trade secrets. And trade secret protection varies significantly from country to country, whereas most patent protection is pretty similar in all countries to grant patents, is you have the right to exclude others from practicing your patented invention in that country. So now we're going to some relevant terms. So relevant transactions, NDAs, development and manufacturing agreements, and patent licenses. So what's an NDA? It's the handshake agreement when sharing confidential information with joint developers, manufacturers, suppliers, investors, employees. Now, employees you do often through an employee handbook, which will say anything that you are shown in or you're privy to during your employment is covered under confidentiality agreements. Clients, etc. Anyone, if you show your information to someone without an NDA, not only can you lose your trade secret protection, but in certain instances, you can also lose the ability to file for a patent. So it's very important to have NDAs in place. Some key terms are scope, exclusion, duration, and disclaimers. So scope, you want to narrowly tailor the NDA's purpose inside the discussion, the initial portion of the NDA, the preamble of the NDA. You want to require the receiving party only share with those having reason to know, and that because of this narrowly defined purpose, you prevent the receiving party from sharing with anyone they want. If you have a very broad purpose, for example, party A and party B wish to share information for the purpose of considering future opportunities together. Well, they can effectively share that information with anyone, right? But if you have a very narrow purpose that only allows certain people within a company to see your information reasonably, then there's a much less likelihood that your information is going to be misappropriated and you have longer protection. However, you should be cautioned that when you do define a narrowly tailored purpose, which is important, you should also not share information that falls outside that scope. You should also not implicate the request to do work under an NDA. An NDA is usually for discussion only, and when you're going to do work, you have more of a definitive agreement, manufacturing agreement, a supply agreement, or licensing agreement. Those agreements take the place. Under those agreements, you could have work orders and the like, where you're asking for work to be done. NDAs really should be used only for discussion purposes. So exclusions in NDAs. You want to have exclusions because if you don't, a court can invalidate your NDA for being onerous. Anything within the public domain, you show it to somebody, they should not have to keep that secret. Anything they're legally provided by another party or they come up with on their own, if you show it to them, they shouldn't have to keep that a secret. And anything also, if you give them the right to disclose, there should be provisions where you give the person the right to disclose, the other party the right to disclose. How long should the NDA, the confidentiality obligations under the NDA last? Well, the question is, how long do you need that information to be secret? If you're going to publish the information sometime in the near future in a patent application or a white paper or some type of other public display, then you really only need the NDA to last until that period for the confidentiality obligations. Otherwise, it could be indefinite. If you deal with trade secrets and the value is something that you're going to need for an extended period of time, 15, 20 years, you don't have to limit the term for confidentiality related to that information. So this, the Uniform Commercial Code has statutory provisions in states where it is accepted, and the statutory warranties that are and implied warranties. And if you don't mention warranties inside your NDA,
Oh, non-disclosure agreements.
Yes, in NDAs, right? In non-disclosure agreements. Right. If you don't, and so in your NDA, if you don't disclaim these, they could be read into it, right? So you want to disclaim. You want to say the information you're providing is being provided as is. Indicate there are no express warranties, which are otherwise express warranties would be warranties that you actually have in your agreement. So just say there are no express warranties here. And you want to disclaim the UCC warranties, merchantability, fitness for purpose, accuracy, and completeness. Now, these disclaimers are good for many things, but they're not going to be helpful for fraud or fraudulent misrepresentation or fraudulent inducement. Just an FYI, you can't disclaim that. So now we turn to development and manufacturing agreements. Now there are many more terms in NDAs. We're going over real basic stuff here. I run a boot camp in the fall that's about 6 or 7 weeks long, 2 hours a week. And so that's transactional boot camp. So there's only so much we can go over here tonight, but there's a lot more to know about these things. But these are some key terms that are very helpful for you to understand. So IP ownership, license to background, intellectual property, indemnification, milestones and reporting, and reps and warranties are useful terms in these agreements. So IP ownership, there's two flavors, at least, single party ownership versus joint ownership. So rather than explaining why we believe single party ownership is best, well, I'm identifying issues with joint ownership. Your co-owner can undervalue your IP in a license to a third party or a license to a competitor of yours. They can independently license and sell and exploit the patents without your approval and without having to account to you for profits. They must agree to grant an exclusive license to a third party that you may want to grant that to. A patent cannot be enforced in a litigation unless all co-owners join the lawsuit, and they may not want to. They may have conflicting viewpoints on how to handle prosecution and filing strategies before the U.S. Patent Office or patent offices around the world. All the above can be resolved in contractual terms, except contracts can be challenged and breached, and so it becomes much more of a long-term concern with a patent portfolio that could last decades, how to handle joint ownership of intellectual property. Okay. We hear somebody typing in the background. I'm not sure if that person can put their themselves on mute. That'd be helpful. Hi. All right. License and background IP. This is important if you're going to have, if the other party, if you're in a joint agreement, the other party is going to develop an intellectual property that you're going to need. So a new widget, a new manufacturing process to make a widget, or the like. They may be bringing their background in intellectual property into it. Maybe it's coatings for the widget, maybe it's a process of making the widget. So you want to obtain a perpetual, non-terminable, paid up, non-exclusive license to their background IP to the extent necessary to practice the developed IP. Otherwise, they will still have the right to exclude you from practicing their background IP, which may prevent you, if it's a key enabling technology, may prevent you from being able to practice the developed IP. You may want to consider having an updatable table of background intellectual property that you create at the time of executing your agreement, and that's updated from time to time. Indemnification. So it's an important safety net if there's any IP grant from the other party to you under the agreement, such as a manufacturing process. The other party should indemnify, if you want to, for indemnification purposes, you want to have them indemnify, defend, and hold harmless you in the agreement, right? So obligations to defend begin when the complaint is filed. So if somebody sues you for infringement, there's an obligation to defend that begins at the time. Obligation to indemnify begins when judgment is entered, which identifies an actual loss, which could be significantly later down the road from the time a litigation is initiated. And hold harmless ensures that you'll not be sued by the other party to the agreement for any losses that they may have under any legal theory. So defend, indemnify, and hold harmless. Language should also include, it should prohibit the other party from settling any disputes with an admission of wrongdoing on your behalf or an obligation to pay sums without your consent. Milestones and reporting. You want to identify specific quantitative goals you expect to reach as part of a commercialization plan. This will ensure that the party is diligently working according to measurable expectations so that you can exploit your IP. You have technical milestones, development of prototypes, completion of preclinical trials, and the like. You can have commercialization milestones, first manufacture, first sale, etc. And you can have funding milestones for startups. And to the extent milestones aren't met, you can change the terms of the agreement, get out of the agreement, and choose other avenues to exploit your intellectual property. Reps and warranties. There are dozens and dozens of reps and warranties. And each circumstance may require different reps and warranties. So what do? They give the ability to walk away from an agreement if the reps and warranties are not met. Basically, at the onset, the other party's telling you a lot about themselves. You don't know for sure if it's true, what they're saying is true. And you may want to be able, if it turns out what they're saying is not true, maybe they'll want to walk away, right? And oftentimes parties will have liquidated damages in their agreements that are available if there's a breach in these reps and warranties. So we talked about background IP that should be available under an agreement for you to practice developed IP. So for that background IP, this is a small set of reps and warranties. There's no dispute or litigation associated with it, no encumbrances that would prevent you from practicing it, no conflicting grants with third parties, no infringement of other IP as a result of it. You know, it wasn't stolen from another party. There's no material information being withheld. The list is complete. Also, to the knowledge, you may want to say to the knowledge of the other party. Also, information helps you at the onset feel comfortable, gives you reassurance that you're entering the agreement knowing everything you need to know to get things moving. So patent licenses. This gives you a passive income stream. That you're not manufacturing, right? You're not selling, you're licensing your IP rights. There's exclusive and non-exclusive licenses, field of geographic use and geographic restrictions, and common royalty options. So what are exclusive licenses? Well, it's a singular point of exploitation. It enables licensee to sue, to enforce your IP without you being involved. Usually in these situations, they enable the licensee to develop and register new IP off of the IP that you're licensing to them. It's completely passive this way. You're basically hands off, which is great for a lot of people. But let's say you want to be more involved. Non-exclusive licenses are the alternative. You may obtain a diversified portfolio of royalty streams from a variety of licensees. And you can also continue to develop IP coverage on these technologies. So different types of non-exclusive licenses include field of use and geographic restrictions. So why would you use these different types of non-exclusive licenses? Well, you may have technology that has multiple distinct uses within a territory, so field of use restrictions, or different market strengths within a territory. So you have geographic. So territory here would be like, for example, the entire United States patent. So you may want to have certain parts of the country licensed to certain licensees and certain other licensees, because maybe there's different market strengths or different price strategies. And it also provides you control, and you may want to continue developing the intellectual property around your innovations. With complex technologies, so you should be aware when you're drafting these types of agreements, you're going to want to very clearly identify the boundaries of your limitations, your restrictions to the other party. So to the extent there's any unclear discussion or recitations about these boundaries, the parties may believe they can wander into each other's territories or fields of use, and in which case you can wind up in a very ugly situation. So you want to make sure that those restrictions are very clearly defined, so there's no ambiguity. So when you're licensing your intellectual property, there are different models for royalties: percent of profits, fixed fees, fixed payments, variable rates based on a number of units sold, minimum annual rates, monthly, quarterly, annual payments. Why would you choose one over the other of these options? Depends on the type of license. It's exclusive, non-exclusive, are there restrictions? What's the market maturity? What's the market strength of your product? What development stage are you at? Is it just initial stage, or are you at a point where you're able to mass produce it? Are there commercial options that are available that are suitable replacements to what you want to sell? You may be able to ask for less as a result. If not, you can ask for more. What's the cost to manufacture a product covered by the patent? If the cost is high, then depending on the market value, you may need to seek a smaller revenue stream from manufacturing, or maybe you want to increase the value because people will pay the added value for both marketing. pay the manufacturing cost as well as the cost that you want for your royalty stream. So I'm done with my part of the presentation. We're going to be speaking next about going into trademarks. And Sarah's going to take over from here. But if anybody has any questions, I'm happy to take a moment out and answer any of these questions. Okay, great. So I'm going to hand the, so Catherine, you have the control back, right?
Yeah, I think Sarah, you should have control now.
Yep, let me check. Not yet. Oh. And let me do the stop remote control and request it again.
Okay. Try it now.
Oh, technology never wants to work. Okay, there we go. There we go. Sorry about that. So I'm going to discuss the basics of what a trademark is and relevant transactions that involve trademarks. It doesn't want to work for me again. Okay, so just a basic overview of what I'm going to go over. I'm going to start with trademark law and how they work in transactions, specifically involving transactional IP. I'll discuss both assignments and licenses, and if you have any questions, just ask them along the way. So to begin, what is a trademark? A trademark is any word, name, symbol, slogan, design, or device, package design, color, sound, touch, smell, or combination thereof that identifies the source of a goods and or service used in connection with the mark and distinguishes that source from others in the marketplace. The function of a trademark indicates the source or origin of the goods or services and assures consumers of the quality of the goods or services bearing the mark. Basically, the takeaway would be that a trademark is used as an identifier. It could essentially be the reason a good or service continually gets used or purchased. If someone sees a trademark and recognizes it and has a positive association with it, they're more likely to go and purchase or use that good or service again. And just so you all are aware of the difference between a trademark, service mark, and trade name, trademarks identify and distinguish goods, service marks identify and distinguish services, and trade name or the commercial name is any name used by a person to identify his or her business. A trade name cannot be registered as a trademark or service mark. And just to show you some examples of trademarks, I'm sure you've all seen these probably everywhere. Coca-Cola stylized written on the bottles. The golden arches, great example is when you're driving on the highway. You see those golden arches, you automatically know that that symbol is McDonald's. And so that M symbol clearly makes it known that it's McDonald's from any other fast food restaurant. And then the slogan, just do it. Everyone knows that from Nike, service mark, Amazon.com, and a trade name, as I discussed before, Amazon Technologies, is just the commercial name. And also, I think it's important to know that when you're talking about trademarks, distinctiveness is going to determine the amount of legal protection that your mark has. When you are trying to register a trademark or a service mark at the USPTO, which is the United States Trademark and Patent Office, you have to identify and distinguish the goods or service, and this is known as distinctiveness. So as you can see, there's a spectrum from strong to basically no legal protection. And if you're going through them, obviously fanciful and arbitrary are going to have the strongest legal protection out of all of them. And an example of a fanciful mark that would be basically an invented word or phrase. A great example for this would be Xerox for copiers. Arbitrary, that would basically be an existing word that has no relation to the actual goods or service. This could be Dove soap for hygiene products. Suggestive which is now going into the weak category, would be something that suggests or hints at the good or service that your mark indicates. This could be copper tone for suntan lotion. And then going down to generic, it should be noted that that's completely ineligible of trademark protection. It's just a common word for a good or service, such as a scooter for a foot-powered scooter. And then protecting a trademark. Wait, I might have, okay, yes. Clearing a trademark. A mark must be cleared for availability. So what you're going to want to do is determine the use of the mark, goods or service, and then expanding the use in the future, kind of having your plan. And then you can determine the availability of the mark, which would be the searching process. And if your mark is identical or confusingly similar to a prior registered mark or mark that is subject of a pending application, or it is being used in the same market as an identical or confusingly similar mark in connection with similar goods or services, you likely aren't going to be able to get that mark because it would cause consumer confusion. Now, obviously, the end goal is to protect your trademark from others. So I'm going to briefly discuss how to protect your mark and how that works in the US. And it should be noted that trademarks in the US are established through use of commerce, and rights based on use alone are called common law rights. And these common law rights occur when one hasn't filed state or federal registration. So your trademark protection is based solely on using your trademark in commerce within a particular geographic area. This seriously limits your rights because you are only enforcing your trademark rights for that specific area where your trademark is used, whereas a federal registration puts the whole nation on notice. And then with a registration, you are able to file a trademark application based on intent to use, but no registration will issue until the mark has been used in commerce. This is why use in commerce is so important for registering your mark for the utmost protection. Further things that you need to register your mark would be the mark, whether it's a good or service, the filing basis, whether it's the intent to use or if it is in use. If it is in use, the date of first use, the owner of the trademark, and signature. So now going into transactions and what type of transactions can help exploit the value of one's trademark. Today, we're going to discuss assignments and licenses more in depth, but you may also use a trademark as collateral to secure financing. And I think it's important to understand the value of a trademark and why people do enter into specific transactional agreements. A trademark is one of the most important assets a business will ever own. It can act as their identifier, reputation, how a consumer finds them. And it's important to know that the value of the trademark lies in the goodwill that's associated with the mark. The goodwill is defined as the desirability of the goods or services which are identified by the trademark or service mark. And the goodwill is an intangible asset which is identified by the trademark or service mark, and it basically values the overall business. So it can be quite difficult to assign a monetary value to it, but there are some formulas if you want to dive deeper into that. It basically equates the consumer recognition of the mark and the earning power that the mark can generate. And the trademark goodwill is the customer's willingness to buy from that source again, is essentially the reputation of the business. And we're going to touch more back on goodwill when we go into assignments and licenses. So the first transaction that we are going to discuss is an assignment, which is a legal instrument that is used to transfer a trademark owner's rights, title, and interest in a trademark to another party. The transfer.
See how effective this is.
Bring you out of the room. I want to hear this, Jay. would you take your plate and put it in the?
Sure.
That fast. I felt him coming in the east like that. He's going.
Boys, you guys got your mics open. You gotta check that.
You want me to stop?
Yes, I'll check.
Sorry about that. So the transferring party, known as the assignor, transfers its property rights in the mark to the receiving party, which is known as the assignee. And as I stated before, we're going back to the goodwill, especially in assigning trademarks. The goodwill must be included in a trademark assignment. Moreover, a trademark and its goodwill should follow a business if sold. And if no transfer of the trademark occurs with the sale of the business, you could have an assignment in gross. In other words, it is the transfer of a trademark without the goodwill of the business. An example of this would be Starbucks can't just sell you its Starbucks trademark. You have to buy their coffee business with it too. If you could simply just sell a trademark without the underlying goodwill, then a consumer would never know whether to actually trust the brand name. So it's important to understand that a business and a trademark are linked by law, specifically in the Lanham Act, which states that a trademark can only be sold or transferred with the goodwill of the business in which the mark is used. Now moving on to some key provisions to put into a trademark assignment. I know Dave talked about some of these and Catherine's going to talk more about these provisions later on, but just to go over some of them briefly, beginning with the party, as we discussed before, identifying the assignor and the assignee. The recitals, these are like the whereas clauses. This is where you define the nature of the assignment and offer all the key background information about the parties. The recital will also include a simple statement of intent to transfer rights in the trademark. The assignment of the marks, this will further discuss the actual assignment and the acceptance of the assignment. You want to be as clear as possible here as to the property being transferred and emphasize the goodwill being sold with that property. Remember, assignments attempted without goodwill are considered invalid. And then consideration, in most agreements, each party is expected to do something. In this situation, assigning a trademark, the assignee is giving money to receive the assignor property. Be sure to enter the amount being paid and how long the assignee has to make the payment after the agreement is signed. Reps and warranties, those were discussed a little before. In a situation like this, the assignor would basically be swearing that it's the owner of the trademark. It is not sold or transferred the mark to any third party. It has the authority to enter into such agreement, and it does not believe that the mark has been taken from any third party without authorization. For the assignee, it is basically just promising that it has the authority to enter into such agreement and has the funds to pay for the assignment. And in these reps and warranties, either party can add additional reps and warranties. It just depends on like the needs of the party. And then a few more key provisions for a trademark assignment: no further use of the marks. This indicates an effective date of the agreement where the assignor will stop using the trademark. Indemnification. This describes the party's future obligations in the trademark. If anything is found with infringement with the third party rights. Governing law allows the parties to choose the state laws that will be used to interpret the document. Severability protects the terms of the agreement as a whole, even if one part is later invalidated. So for example, if a state law passed prohibiting some sort of clause, like a choice of law clause, it will only make that section invalid rather than undoing the whole agreement. And then lastly, the list of trademarks are obviously very important for a trademark assignment. To be effective, the marks being transferred must be clearly identified. So attaching some sort of registration or samples that you may have. And of course, all of these provisions that can be added, and some of them discussed may be omitted in some agreements, depending on what the party wants. But these types of transactions will always differ based on the party's needs. But all the provisions that we're discussing here are set in place to basically protect both of the parties. And then we will go on to discuss another common transaction that occurs when it comes to trademark, which is known as licensing the trademark. Unlike an assignment, which transfers all the rights, a license allows the owner to maintain their rights and interests in the IP. So in this case, the trademark. And a license agreement is when the trademark owner, known as the licensor, grants permission to the licensee to use that trademark on mutually agreed terms. And I want to emphasize here quality control in a license agreement. The whole essence of a trademark licensing agreement is that the licensor mostly retains control over the nature and quality of the goods or service sold in association with that trademark. So without quality control, a naked license may occur. And if this license occurs by the trademark owner failing to exercise adequate quality control over the licensee's use of the trademark, such that the trademark no longer represents the quality of the product or service that a consumer has come to expect, then the trademark owner may risk forfeiting their rights. So some people may ask, why enter into a trademark licensing agreement instead of an assignment? And all of these examples below, they benefit both parties, but these licenses can really help a company expand to new markets effectively and easily, while lending the licensee an established name and reputation. So to list a few: revenue stream, product expansion, territorial expansion, benefiting from someone else's manufacturing or that capacity, or increasing brand awareness. With this kind of agreement, you're essentially
Oh, Sarah, I think you're on mute.
Was I on mute for a while?
No, just a little bit.
Oh, did that happen? Okay. All right, and as stated before, in the case of assignments, licenses as well vary in length, clauses, some structure, but I'm going to explain below some key provisions that I've constantly seen in license agreements. Some of them overlap with assignment provisions, so those will be brief. But obviously the parties and the IP, just identifying those parties and the trademark to be licensed. Goods or services, terms and territory, identifying the nature of the goods and services, the contract terms, and the geographic territory. Often the license use is very specific. So for example, a licensor may limit a certain channel of distribution. Definitions, these are just a section where the key terms are defined, so there's never any confusion within the agreement. Quality control, as I spoke about before, a detailed quality control clause is critical to a trademark license. Control by the licensor is required because the mark represents the owner's reputation and goodwill. Consumers rely on the trademark owner's reputation with regard to the quality of the goods when making purchasing decisions. So the goodwill was also heavily discussed during assignment agreements. So as you can see, there's kind of a pattern that happens within these trademark agreements. And then exclusivity, there is 3 types that can happen in this license agreement: exclusive, sole, and non-exclusive. Exclusive would be the rights will be granted to the licensee to the exclusion of all others, including the licensor, who was the owner of the trademark. Sole, which means the rights will be granted solely to one licensee, but not to the exclusion of the licensor. And non-exclusive, which means that the rights can be granted to other third-party licensees. In addition, the licensor may use the trademark in commerce. And then compensation, this was discussed earlier too. Royalty payments based on percentage of net sales could be put into such agreement. Oh, no, that's not it. Okay. There might be some clauses having to do with litigation that establishes the party's rights to enforce such mark. Warranty, which was also discussed in the assignments, they are going to be in licenses too. And an example could be that the licensee may require that its interests be protected through a clause where the licensor provides an express warranty of non-infringement. This may involve the licensor agreeing to indemnify the licensee for any expenses relating to any infringement of said IP. And then termination and right to remedy. These are just provisions that try to encourage the parties to work together to resolve some minor disputes. Arbitration, this is just a provision that can be put in as a cost-effective way if a dispute does arise. It's common practice to provide that it be resolved via arbitration. And then choice of law and forum, they provide certainty pertaining to the enforcement of the agreement. And then in the end, there's no better transaction or secret formula to create the best trademark agreement. Every transaction agreement that has IP involved is truly based on having the parties' wants and needs in each agreement. The provisions that we discuss are certainly going to allow a party to be heavily protected when entering into a trademark agreement, which is what we want every client to experience. A sense of complete protection of their IP rights or a smooth transaction if assigning one's rights. But if you guys have any questions, feel free to ask. And I know Catherine is talking next, discussing copyrights and those relevant transactions. Thanks.
Thanks, Sarah. I'm just gonna request control or stop controlling. I think I should have it. All right. So moving on to my portion of the presentation, which covers copyrights and relevant transactions. So just a brief overview of what we'll be covering. We'll be covering what is a copyright, why are copyrights important, copyright ownership, and some methods of transfer of copyrights, including assignments and licenses, similar to what Sarah did with trademarks. And if there's time, a question and answer session. So what is a copyright? A copyright protects the expression of an idea, not the idea itself. Copyrights arise in original works of authorship. There's minimal degree of creativity that's required, and works are deemed original when they are independently created by a human author. So independent creation simply means that you create it yourself without copying. They're also fixed in any tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated either directly or with help of a machine. So for example, a work is fixed when you write it down or you record it. And it's also important to note that the US Copyright Office recently rejected a request to let artificial intelligence copyright a work. So it is important to note that human authorship is a prerequisite to copyright protection. So an original work of authorship can be a number of things. It can be literary works, it can be musical works, it can be sculptural works, any number of those. Some examples include books, paintings, sculptures, movies, plays, and others. So a couple examples of what is not protected by copyright include ideas, methods, and systems, and these also include procedures. So for example, a recipe. A recipe is typically a statement of ingredients and a procedure required to make a certain dish. But it should be important, or it's important to note that recipes can be copyrightable in some instances. For example, if the recipe creatively explains or depicts how or why to perform a particular step, it may be subject to protection. Names, titles, and short phrases are not protectable. Same thing with typeface fonts and letterings. Blank forms such as scorecards, graph paper, time cards, those aren't protectable. Works that are not fixed in a tangible form, so improv speeches or performances that aren't written down, and then also familiar symbols and designs. So for example, letters, punctuation, or symbols on a keyboard are not protectable, or symbols that are in the public domain, like a peace sign or gender symbols that you often see in connection with restrooms. Those are not protectable. So copyright also does not protect any utilitarian or useful aspects of a work unless the copyrightable authorship can exist separately from the useful elements of a work. And examples of useful articles are things like clothing, furniture, and lighting fixtures. So as noted, a useful article can have both copyrightable and uncopyrightable features. The test is really if it's separable, then it's protectable. And a good example is a carving on the back of a chair. The carving is separable as a separable element from the chair and is protectable, but the chair itself as a whole is not. So why are copyrights important? So a copyright owner exclusively holds a bundle of 6 separate and independent rights for the period of time that the copyright remains in effect. So the first right is the reproduction right. This is the right to make copies of your work. The next is the adaptation right, which is the right to make derivative works. And a derivative work is based on a pre-existing copyrighted work, but recasts, transforms, or adapts the original expression to create something new. The next is the distribution right, which is the right to distribute copies of your work. Next is the performance right, which is the right to perform your work publicly. There is also a performance right that's specific to sound recordings. So for instance, it grants owners of a copyright in sound recordings the right to perform the copyrighted work via a digital audio transmission. And last but not least is the display right, which is the right to display your work publicly. In addition to this bundle of 6 independent rights, US law does also recognize what are called moral rights. These are more of a concern in international copyright law, but they should be mentioned because they are recognized by US copyright law. These basically protect the personal and reputational value of a work to its creator, and they're protected by various state and federal laws, but they're mainly protected by an amendment to the US Copyright Act known as VERA, which VERA is pretty limited, it's narrow. It only applies to certain works of visual art. And works of visual art include paintings, drawings, prints, sculptures, and the like. And for purposes of this presentation, it's important to note that under VERA, moral rights are not transferable by license or assignment, but they are waivable if in writing. So moving on to copyright ownership, who owns the copyright? Generally, the owner is the creator or author of the copyright. It can be a single creator or author, or it can be a joint work. And there's a couple exceptions, which are works made for hire or independent contractors that we'll go over. So a joint work is prepared by 2 or more authors with the intent that their contribution be merged into a unitary whole. Authors of a joint work are co-owners of the copyright in the entire work, and they also have the independent right to use or license the copyright of the entire work, but they must account for and pay revenue to the other authors. And this is an important distinction to draw from patents that Dave discussed previously. For example, patents with joint owners or inventors each have the right to make, use, license, sell, and import the patented invention without the consent or accounting for the other co-owners of the patent. So important difference to note between patents and copyrights here. An exception to copyright ownership are works made for hire. So when a work is made for hire, the author is not the individual who actually created the work. Instead, it's the employer or the company that requested that the work be created, unless there's a signed written agreement that states otherwise. And whether a work is made for hire is extremely fact determinative. There's typically 2 situations in which a work made for hire will occur. The first is when the work is created by an employee as part of the employee's regular duties, or essentially when it's within the scope of the employee's employment. The second situation is when an individual or the employee and the hiring party or the employer enter into an express written agreement that states the work is a work made for hire and that it's specially ordered or commissioned for use as a compilation, a contribution to a collective work, a test, and the like. The next exception to copyright ownership are independent contractors. If a work is created by an independent contractor, it won't automatically constitute a work made for hire unless there's 3 requirements that are met. The first is that there must be a written agreement that expressly states that the work is made for hire. The second is that the work must fall into one of 9 statutory categories, or in other words, it must be a compilation, a contribution to a collective work. This list of 9 categories on this slide that we just went over. And then the third requirement is that the work must be specially ordered or commissioned. Otherwise, it won't constitute a work made for hire. So how is ownership of a copyright transferred? A copyright is personal property, therefore it's freely transferable in whole or in part. To be valid, a transfer must be in writing and must be signed by the copyright holder or its duly authorized agent. And there's a couple methods of transfer of a copyright. For purposes of this presentation, we'll mainly focus on assignments and licenses, but it is important to note that they can also be transferred by will, by gifts, transfers by operation of law, so bankruptcies or mortgage foreclosures, things of that nature, and also involuntary transfers. So the first method of transfer is copyright transfer via assignment. So the transferring party, or the assignor, transfers its property rights in the copyright to the receiving party, or the assignee. The effect of an assignment is to grant the assignee all right, title, and interest into the copyright. And what this does is this results in a loss of the creator or author's control and ownership of the copyright. And it's important to note that both registered and unregistered copyrights are assignable, and they can be assigned in the same instrument or agreement. So there's a couple common scenarios where copyright assignments come into play. I have 3 listed on the screen. The first one is when an individual initially creates or owns a copyrightable work, and then later forms a business entity where it wants to transfer the copyright or assign the copyright to. The next is a copyrighted work is sold as part of an asset purchase agreement or other sale of a business, or when a company or group of related companies wants to assign their copyrighted works to an IP holding company. There's also different scenarios that could come into play. So for example, as a result of litigation, a copyright dispute can result in the transfer of a copyrighted work as part of a settlement or a court mandated order, or when an entity is dissolved or is taking over the licensing from another entity, an assignment will typically come up. So there's a couple of key steps in a copyright assignment. The first and most imperative is that you're going to want to verify the rightful owner or owners of the copyright and that they actually have the right to transfer the copyright. Next, you're going to want to confirm that the assignor and the assignee are existing entities at the time the copyright is assigned. So for example, if an assignee is a corporate entity, you're going to want to make sure that the entity actually exists at the time the copyright is assigned. Otherwise, assigning IP to a defunct or a to-be-formed entity will result in the invalidation of the assignment and underlying IP rights, which no one wants. You're also going to want to have a signed written agreement in place, preferably before the work is created, but it's not required. It's also recommended to record the assignment with the U.S. Copyright Office. Again, this is not required, but it's recommended to ensure proper chain of title. But a quick note on recording with the U.S. Copyright Office is that once recorded, the assignment becomes public. So you're not going to want to include any confidential or financial or other terms that you don't want others to see.
Catherine?
Yep.
Quick break. So we want to allow for 10 minutes of questions. So we want to wrap this by 6:15. Is there any way that we can go through the next 5 or 7 minutes with the rest of your slides? Is that possible?
Yeah, you bet. There's a bunch of terms that both you and Sarah have already covered, so
Right.
They're essentially the same. So we can just quickly skim through those.
Sure, terrific.
So as I was mentioning, there's a couple of key provisions that Dave and Sarah have already addressed, the basic essentials, identify parties and whatnot. You're also going to want to identify the copyrighted works themselves, either within the assignment document or if there's a lot, either on a schedule attached thereto. You're going to want to include the copyright registration numbers, the titles, or full descriptions of both registered and unregistered works. You may also include provisions regarding an assignee's right to sue, or signature blocks is another important one too. It's best practice to include blocks for both the assignor and the assignee, even though it's just the copyright owner or its duly authorized agent that needs to execute a copyright assignment. Another method of transfer is via license. The copyright owner or the licensor can license any of its bundle of exclusive rights or subdivision thereof to another, which is the licensee. There's generally two types, which is an exclusive license and a non-exclusive license. These are similar again to what Sarah and Dave have previously covered. A couple of key steps for copyright licenses. You're going to want to identify the rights that the licensor wants to grant and which the licensee wants to obtain. And important to note is that copyrights are kind of unique and different from patent and trademark rights in the sense that they include the bundle of rights that may be licensed separately. You're also going to want to identify the provisions to include in the license agreement, which are a bunch that Dave and Sarah have already covered. These include the grant of rights, license term, royalties, indemnification, reps and warranties, and the like. So we'll go over the grant of rights provision, as that's a pretty important provision. The provision is important because it transfers the copyright rights from the licensor to the licensee. Again, you're going to want to include the complete description of the licensed works, including the copyright registration information. And it's recommended to use the names of the granted rights that are used in the Copyright Act, so the reproduction right, to avoid any ambiguity. In the grant of rights provision, you want to specify the degree of exclusivity, again, whether it's exclusive or non-exclusive. This is critical because economic value is typically tied to a license. It's generally higher if it's exclusive. You want to identify the licensed territory, whether it's worldwide or a particular country. And you'll always want to identify the license term. Otherwise, if a license agreement is silent as a term, it will be construed to last the duration of the copyright, which can be a pretty long time. Generally, the modern copyright expires 70 years after the author's death, but duration can be complex and there's many factors, so that's for another day. Again, royalties provision, one of the reasons why you'd want to license a trademark or a copyright, excuse me. You want to include the royalty base, which is what the royalty is based upon, whether it's each unit sold or each unit made. The royalty rate, which is the amount of money to be paid to the licensor, calculated using the royalty base. So for example, $5 per unit sold. And you'll also want to specify the royalty reporting and auditing procedures. So timing of royalty payments and royalty reports that show the licensee's sales and revenues and profits. Other than that, it's basically the same kind of provisions that Dave and Sarah covered as far as indemnification provisions, defend, hold harmless, things of that nature. Reps and warranties, these are typical in every modern contract. There's two that are specific to copyright licenses. This is a warranty of non-infringement that basically warrants the protected work. It doesn't infringe a third party's IP rights, or a warranty of valid copyright registration that warrants the copyright was duly obtained, valid, and currently in force. And last but not least is the transferability. So the licensee can have the ability to transfer the license rights via assignment or sub-license. Could be depending on whether the agreement's exclusive or non-exclusive. And there may be cases where the licensor may want to maintain some control over the licensee's assignment or sub-license. For example, if her protected works affect her quality, could be diminished by careless reproduction or sloppy performance, then that's a situation where the licensor may want to maintain some control. And with that said, I think that wraps up my portion of the presentation. I think we can open up the floor to any questions for either myself, Dave, or Sarah.
Yeah, I think there's some questions in the chat too. If we want to answer those.
So I think I've been answering the questions in the chat as they've been coming up. I don't know if anybody has any other questions. We certainly appreciated your time and thank you for coming. It's a lot of effort that we put in. Sarah and Catherine have done a terrific job and conveying information way better than I could. So I'm glad that they're here. So, and
I think there are a few questions. We probably should run through them. One person asks, are NFT images copyrightable?
Right. Okay. Right. So I responded directly. Okay. So an NFT is a link to it's not the subject of the copyright itself because it's just a link, like a token, right? And that stuff is not copyrightable. But the image of the NFT is different, and unless Catherine, you have information otherwise. I believe the image of the NFT in a two-dimensional tangible form is copyrightable, providing it is created by a person, not by AI.
Right,
That's also
correct.
been- Yeah.
As of now.
Right.
Yep.
Yeah, I think it's also the original person or artist that did the work, they have the copyright. You buying this NFT, you're not buying the copyright to that NFT. You're essentially just getting the link.
Right, so it's interesting. So one question that just came up is if you buy the image NFT, do you own the image? So Sarah just touched upon that. You're just buying the, if you get the buy the NFT, you're just buying the link. But with any artwork that you buy from a store, you don't own the original work of art, right? You're not allowed to make derivative works of it. You're not allowed, Catherine was talking about these bundles of rights. You're not allowed to, infringe those rights that are owned by the original author, the creator of the work. You're allowed to display it. They give you a license to display, just like any piece of art that you purchase. Catherine, I'm sorry, I didn't mean to that's your time.
No, that's perfect. Thank you.
So what's the value of the NFT? What's the value of Bitcoin, right? It's, people now are buying, space to do work on in the metaverse. What's the value of any of that stuff? It's intangible, and it's the intellectual property behind a potential alleged limited resource, although it's questionable. If any of you have Bitcoin, the value of that is hard to define. It's the same with an NFT.
Well, I want to thank everyone for Cantor Colburn for coming and speaking for the Inventors Association. I, for one, thoroughly enjoyed the presentation. I thought it was great. Just a few words about what we have coming up on March 24th. We should have a, a presentation by Paul Hubert. He's the president and CEO of Hubert Engineering and Design, and he will come and talk to us a little bit about how he goes through his design process, and maybe a little bit about how he goes through the creative process in general. So with that said, I want to thank everybody for coming to the meeting, and I look forward to seeing you all again at the next meeting. Thanks a bunch.
Thank you.
Thanks, everyone.
Thank you,
Bye-bye.
everyone.
Bye.
Bye-bye.